A very good morning, afternoon, and evening, wherever you might be. And welcome to this session on whether we are seeing a new phase in international law. That is an international law of the Anthropocene. Now, this is a big moment for international law, if indeed we are seeing such a new phase, because previously, in the last 450 years or so of international law, we only have had two phases. That is international law war, international law peace. Now, historically, international law emerged as the rules related to war, hence the first part of the title. Then after the Second World War, it emerged as rules relating to maintenance of peace, alongside those rules relating to regulating war, so that it can prevent a third world war, which it successfully has. But now, are a lot of the rules of international law not just catering to regulating war and to maintaining peace, but to us facing a planetary threat with a very complex enemy, i.e. ourselves. Now, I'm getting quite philosophical with that latter part. Although it is a valid question, we won't be dealing with that. So essentially, this is the background to this session. We can't possibly be dealing with every area of international law today to see how it might have evolved or changed. So we'll be dealing with three areas. One is public international law, second is global policy, and third is international economic law. So with that introduction to the overall topic, I now want to introduce the three speakers. First is myself, Dr. Chamu Kuppaswamy, and I will deal with public international law and the changing fundamentals of public international law. I will be followed by Dr. Moises Covarrubias, who will deal with just transition policy. And then that presentation will be followed by Professor Dr. Catherine Zengeringling. She will be asking the question of international economic law by looking at free trade agreements. We had initially planned for 4 speakers. Unfortunately, the 4th speaker is not able to be here with us. Each speaker will take a little over 10 minutes. And then this will be followed by an intra-panel discussion for another 10 minutes or so on 2 key questions that we will pose. And then finally, we would like to open the floor out for a Q&A as well as a discussion with the attendees yourselves. So with that introduction to the speakers, I'd like to now move on to my presentation. I will be making 7 points in total, and then concluding that there is an evolution in the fundamentals of public international law towards a new phase in public international law in the Anthropocene. So, my first point is the concept of personhood. Now, before I elaborate a little bit on this concept, I have to mention that there is a reason why public international law is the first topic in the consideration of whether there is a new international law of the Anthropocene. And that's because public international law is quite important and foundational to all areas of international law. So with that caveat, my first concept, my first point I was going to make is on personhood. Now, the concept of personhood is important in public international law because it is the concept through which recognition is provided for such bodies as the states. And then from that point on, rights and duties can be conferred under the international legal system. Now, the new development in the area of personhood that I want to highlight is the area of rights of nature. The rights of nature movement historically has evolved through cultural history, ecology, and even some lawyers advocate for the rights of nature. It's just like how humans have human rights, equivalent would be rights of nature. Thomas Berry, cultural historian, argues society's laws should derive from laws of nature, and he explains that the universe is a communion of subjects, not a collection of objects. This is something that is echoed by Cormac Cullinan, who's a lawyer. He writes in his book, Wild Law, which was published in 2003, that recognizing natural communities and ecosystems as legal persons with legal rights is now well underway. Indian ecologist Vandana Shiva has similar views. Professor Stone, a law professor at the University of Southern California, has written extensively. One such essay, Should Trees Have a Standing, i.e. legal standing, was also cited in a US Supreme Court decision. Now, rights of nature proponents contend that revisioning current environmental laws from a nature rights frame demonstrates the limitations of the current legal system, particularly of environmental law. So, for example, the impact that rights of nature can have, if we were to use that as a frame, in the European Union's Water Framework Directive of 2000. Now, this is widely accepted as a very ambitious and substantial piece of European environmental legislation. It targets good status of all waters, which includes consideration of the need for ecological flows. However, after the directive has been adopted, despite a lot of scientific advances in how we can identify ecological flows, how we can identify good status, there is still no EU definition of ecological flow. And therefore, when there is an impact on ecological flow, that does not get addressed. If we use the rights of nature framework in our environmental laws, and rather at this point we can use it to interpret it, but if we were to use it as a main frame, then the health of these rivers, the ecological flows, and the good status of the EU waters will be as important as the human right to satisfy the human right of water by making sure that these water systems provide that. Currently, what's really prominent in our water systems is the human needs as opposed to the needs of the health of the waters themselves. And finally, on the point about personhood and looking at the rights of nature, indigenous legal systems also contribute quite easily into this concept. In fact, it's foundational to indigenous legal systems. And indigenous legal systems also are getting recognition within mainstream legal systems. So drawing on all of this, in terms of looking at rights of nature and how it's evolved, the theories, the national laws, and analysis from the litigation, there may, in the future, be a general principle of law on the rights of natures, which can then form a source of international law as per Article 38(1)(c) of the Statute of the International Court of Justice. And this is where public international law derives its sources of law. So that's my first point that I'd like to make, to show how rights of nature is now able to add a new person in international law. Now, the second development I would like to draw attention to is the concept of environment vis-a-vis Earth systems, meaning that the concept of environment now has moved on to the concept of Earth systems. Although not explicitly, it has moved on implicitly. And Earth systems science that studies Earth systems is a bridge between the natural sciences and the social sciences and societal action. One key example for me to show that international law now takes into account Earth systems more than it does environment, or the new international rules that are forming do this, is the UNFCCC agreement and the agreements that flow from it, including the 2015 Paris Agreement. The institution established under the UNFCCC, which is the IPCC, Intergovernmental Panel on Climate Change, is, as we are aware, a natural systems panel, including natural systems and its impact on society and the issues that come out of the impact. So therefore, this is an example of how Earth systems impliedly now are included or probably at the forefront of the consideration of our consideration of environment and international law. And by that, the implication is Earth systems looks at environment as spheres. So atmosphere, geosphere, biosphere, hydrosphere. And it's in the holistic nature of the approach to environment is what is underpinned by this, and the systems nature, of course, if you want to get technical about that. But I'm not the expert on systems, but I can quite recognize how in law we use atmosphere, for example, quite a lot. And a definition of atmosphere can be seen in the new 2021 International Law Commission's draft guidelines on the protection of the environment. And interestingly, only the atmosphere is defined. The other parts of the Earth systems of the environment is not defined, even though the title of that particular guidelines is environment and not necessarily atmosphere. So we do have a long way to understand exactly the impact of a systems approach to environment in international law. So moving on to looking at a concept that is central to understanding of Earth systems science, which is whether we are moving into a new geological epoch, which is the Anthropocene. Although the Subcommission on Quaternary Stratigraphy has not come to the conclusion that we have moved to the Anthropocene, Earth system scientists are talking about the Anthropocene biosphere, for example, and the fact that humans are having a very significant impact and quite a disruptive impact. That is in many ways what international law has been recognizing through just a couple of examples I gave, which is the UNFCCC and the allied institutions established alongside it. So even though geologically it's not officially a new epoch, we have accepted Earth system science really roots for it, and international law has followed it in a way, perhaps grudgingly, because states are pushing back against the legal obligations that flow from this. And hence, the whole point of today's session, to look at whether there are legal obligations, to look at whether the fundamental nature of international law is actually changing. With that, I go on to my fourth point, which is, what is the implication of Earth systems and rights of nature and new persons on the concept of sovereignty, which is a fundamental foundational concept in public international law? There's a long argument to be made here, but because I do not have the time, and I can point you to some published sources that have come out, including a couple of my articles in the last year, I argue that if we recognize Earth systems, or Earth, to keep it simple, as a person, as a new person, given that there has been national case law which recognizes rivers, forests as their own individual persons with rights, Earth then, as a whole, should be a new sovereign entity. Of course, we can get technical and look at whether Earth can act as a sovereign. And with that regard, sovereignty currently as it functions is always been bestowed on artificial persons. So the nation state as such doesn't have an existence without its population, territory, etc. So we do attach the concept of sovereignty and someone, essentially the elected government if it is a democracy, or the non-elected government if it is another type of governance system within a country, then acts on behalf of the sovereign state. So similarly, if we have Earth as a sovereign, then we can have a entity to organize, to act on its behalf as well. So that means under the new international law of the Anthropocene, are we having a new and quite a powerful sovereign which can impact, the condition of the other sovereigns, meaning that disasters that occur because states' earth systems are disrupted do have an impact on states and its population, and the states have to then respond to that, which is what they have been doing through the UNFCCC and other international agreements. So that's the fourth point I want to make in terms of saying that international law's notion of sovereignty now is expanding. And I'm saying that quite cautiously because I'm aware it is not fully recognized. I come to the fifth point, and in fact, the last main point. There are only a couple of sub-points that I want to make under this, which will take me to my final 7. I want to draw attention to the 2021 International Law Commission's draft guidelines on the protection of the atmosphere. This is a specific, sorry, it shouldn't be atmosphere, it should be the environment. I think that's a Freudian slip over there. It does address, the draft guidelines do address atmosphere, a part of the environment. This is a significant shift in how international law is now regulating the environment. Significant shift because impliedly it completely takes on a systems approach. It completely takes on an interdisciplinary approach. It moves away from the methodology that has been used in other international instruments, and it heavily relies on the understanding of natural sciences in order to devolve new rights and duties. This document, again, is worth a very critical and analytical look. I'm only going to point out two points, which I'll highlight. The first is the inclusion of the concept of atmospheric degradation, which is not found anywhere else in international law. Thus far, atmospheric pollution has been recognized in international environmental law, but now, as a result of all of the work in the environmental area, we now have a general duty that has been designed in the 2021 draft guidelines on prevention of atmospheric degradation. So this directly speaks to one of the Earth system's spheres. So this, again, I use as the reason for looking at how Earth systems language and Earth systems understanding of the environment now is becoming the source of legal norms in the draft guidelines. And have to definitely add and remind ourselves that the ILC draft guidelines are not of the same status as our Article 38 sources, 1 and 2 and even 3. However, they do have a place, they are persuasive, etc. So, I'm going to go into the technical details of how they influence international law and state behavior. And the 7th point with which I want to wrap up is the notion of planetary boundaries, or the planetary boundaries framework, which is also implicitly now part of the concept of atmospheric degradation. So what I mean by that is there's a recognition that there is a tipping point after which the atmosphere degrades. So the concept of degradation, even though its source cannot be drawn from norms that we have in international law, it can clearly relate to the 1 or 2 of the planetary boundaries set out by the Earth systems scientists. So with that, I'd like to conclude by saying that I see that there is some fundamental impact that has happened in the last 30 years or so on the concepts of personhood, sovereignty, and the environment in public international law, which leads me to conclude that we do need to look at and investigate more thoroughly whether there is an international law phase of the Anthropocene. Thank you very much. And I'm going to stop sharing my screen here. I'm going to pass the floor on to Moises.
Thank you very much, Chamu, for the very nice presentation. And once again, good morning and welcome for the rest of the attendees. I'm going to move on into my presentation. Okay, well, my name is Moises Covarrubias, as previously introduced. I'm going to guide you through a policy angle of the just transition to net zero society. So in this presentation, I'm going to touch upon 4 points, and I'm going to be guiding you through an overarching question. Are we transitioning away from the harm caused to Earth systems and therefore its different peoples living in? So I'm going to go through a brief introduction to the concept and practice of the just transition. I'm going to go through the extraterritorial regulation concept and practice. I'm going to introduce a just transitions framework that we developed in our in-house research, and a very brief example of the EU Critical Raw Materials Act recently released this year. So, directly from the UN Climate Change Executive Secretary, transitions must be fair, inclusive, and just for everyone, and leaving no one behind. And this is the very spirit of the Paris Agreement. I think this is the, let's say, the best for this occasion, opening a statement to introduce the just transition, to move towards the Anthropocene discussions. Okay, the transition to a net zero global economy, well, first of all, requires the deployment of clean technologies for which we need critical raw materials. And this is if we aim to achieve the temperature targets as established in the Paris Agreement. To achieve these targets, we require not only sourcing raw materials, but also we require a rapid and a far-reaching transition in the whole society. So at the all governance levels, including the policy, the legal, the economic dimensions, to actually transform society as a whole. In doing so, we need deeper emission reductions in all sectors, as mentioned, especially when it comes to the decarbonization of the energy sector, which is one of the cores of just transitions. And once again, to do this, we need critical minerals. We also need removing or capturing CO2 from the atmosphere. And there are different examples and technologies to do that. When it comes to removing CO2, what emerging and controversial technologies, for example, BECS, biogenic carbon capture, there's a typo there, carbon capture and storage, direct air capture, or carbon capture utilization and storage are one of the sound technologies and yet controversial. All in all, a just transition then needs and actually steers society towards a desirable future, which is a lower carbon future, by focusing necessarily on the dimensions of equity and justice. And we will see, is that so? To put in a more graphical context, okay, if we want to achieve the share of clean energy technologies to be deployed worldwide to attain the just transition, well, there will be a direct link to the demand of critical raw materials, for instance, lithium, cobalt, nickel, copper, and other rare earth materials. As the graph illustrates, there's going to be an increase and therefore an increase in demand for this and potentially a competition for it. Another dimension, moving more towards the justice and equity dimensions, Well, it's not surprisingly, and it's nothing new. It's actually a historical trend that there is an overlap between the dimensions of vulnerability. This comes from a study by the OECD on poverty and inequalities through the green transition. So we can see how the most vulnerable countries to climate change are often the same ones that have the highest poverty rates and the most unequal conditions. So we can see in the map how central and the southern part of Africa are the ones that concentrate three challenges the most, but also some parts in Central America and Southeast Asia suffer from the same issues. So this puts actually pressures on the supply chains for provisioning these critical raw materials, and especially on the people that work on those supply chains, putting some pressures on the social and environmental justice aspects. A little bit more on the data about the just transitions and the requirements in terms of raw materials and raw minerals that we will need to achieve the just transitions. We can see that in transitioning towards the energy transition, mineral mining, well, we can see that 88% of platinum and 70% of cobalt resources are located in context of high environmental, social, and governance related risks. And we can see that from the previous slide too. Over 50% of energy transition minerals are also located on or near indigenous peoples' lands or agrarian communities, which puts extra pressures on the dimensions of equity and justice. Now, moving towards the concept of extraterritoriality in the context of the just transition, we can learn from some of the lessons drawn by the OECD report, the one that I mentioned before, and these are countries on just climate transitions. So one of the main insights about this whole report is that there is a consensual concern, an increasing concern about green industrial policies from developed countries. Think about the EU, think about the EU Green Deal as a overarching policy package that might lead to developing countries being passed over for low carbon investments in favor of more developed countries. And this widens the already substantial gap in low carbon investments. The concept of a just transition, it's also being discussed and perceived not only in terms of justice within a country, but its effects on other countries. So the just transition of the European Union, for instance, has implications and effects on the just transition of other countries. And to achieve the global just transition, we require that, for example, these developed countries as the community of countries as the European Union identify, recognize, and address their unintended consequences, their justice effects on other countries in the making and implementation of their climate policies that might have effects on other developing countries. A little bit from our in-house research, the EU Just Transitions, just as a remark, this is the EU framework. With this framework, we studied the transition to a lower carbon economy in countries in the north of Europe, specifically for the energy intensive industries at different industrial clusters. So we developed a very simple framework which categorizes just transitions into two dimensions: the motives or rationalities of justice. So we can be in front of an energy, environment, climate, or labor justice, rationality of a just transition, or by typology of justice. Are we facing justice issues related to how we distribute justice, the process of justice, or the recognition by the law? Or how do we restore a harm or damage that is already being done? However, we didn't look at the extraterritoriality in our research and in our framing of the just transitions, because a very simple reason: we didn't look at the effects of the just transitions of these energy-intensive industries in Europe in other sides of the world. But this raises a big question, and this raises actually new research on the EU Green Deal and how it's causing extraterritorial effects on other countries. Moving on to briefly to this example, the EU Critical Raw Materials Act that was released in April, if I'm not mistaken, of this year. With this, we try to shed light on, is this a just transition or an unjust transition? It's an open question for discussion. And if it's so, who is this transition just for? So I'm gonna go through a couple of the main critiques from the scientific literature. So the EU has been seen as highly reliant on imports to secure carbon critical raw materials, which are essential for maintaining the climate neutral internal market of the EU and to achieve its just transition. So there is a huge reliance on that. That is also rising geopolitical tensions and increasing competition for this critical material with other major economies. We can think about, for instance, China. We can think about other, maybe not major economies, but some countries in South America that are very important and depend on this mineral trading. And this is making it more challenging to obtain these raw materials, especially causing an effect on extracting materials from developing countries or regions. If we think about our previous slides, often these regions are places in the world that are originally indigenous regions. Critical raw materials mining also leads to multiple conflicts, and some of these are rooted in colonial legacies, which are not fully addressed within existing regulatory frameworks. And this is something to work further on. Not from the scientific literature, but from the OECD report that I've been sharing with you, the energy transitions, all in all, can jeopardize indigenous people rights. What we need, it's a human rights-based approach that recognizes the historical injustices that the indigenous peoples and humans in general have faced, including colonization, land dispossession, and cultural marginalization by states and development actors like corporations and investors. And to wrap up, further efforts to ensure the material or critical material security by, in this case, developed countries and through their main policy packages, such as the European Green Deal or the Critical Raw Materials Act, perpetuate a historical pattern of colonial and neo-colonial relations. And this happens in 4 ways found in the literature: turning ecological crisis into business opportunities. I think this is not surprising for most of us. Framing the EU or any other developed country as a moral actor who says, okay, this is the way to go forward in policy and good governance. Reinforcing a green agenda aimed to improve the status quo of provisioning systems or the way we regulate the environment, and by consolidating power through securitization of minerals. With this, the question remain: is this a just or an unjust transition? And if it's so, is it a just transition for whom? And I'll come back to you with further discussions around these lines of discussions and questions after the 3 presentations that we have prepared for you today. Thank you very much, and I will stop presenting now.
And our final speaker is Catherine. Please, the floor is yours.
Thanks, Chamu. Thanks, Moises, for your presentations and for having me in that session. I will also share my slides. Can you see the screen? Okay.
Yeah, we can.
All right. So my presentation is going to be on focusing on international economic law, and the question, I'll follow the question whether we see actually fundamental change in free trade agreements in a way that we could find evidence that international law has entered a new era of being responsive to the Anthropocene. Some background information, what do we observe? And I'll focus on the free trade agreements of the European Union in this whole presentation. So we observe a growing number of free trade agreements. We see deep integration, economic integration that goes far beyond regulation that we have seen under the WTO so far. Some free trade agreements also integrate investment chapters. The newer EU FTAs don't do that anymore. We have different blueprints. The US, EU, China, they start negotiations based on different blueprints. The question remains whether these free trade agreements are actually building blocks or stumbling blocks of future, maybe more multilateral action again, as we had it in the past, where most of this economic integration happened under the WTO umbrella, and now diversified more since we do not proceed under multilateral negotiations anymore. In the last 10 years, we see a bit of a change in these free trade agreements, and we see that they include the EU FTAs. At least they include a separate chapter on trade and sustainable development, the so-called TSD chapters, and the content is also evolving, so it's getting longer and longer, this TSD chapter. Another new thing is that the EU FTAs have to undergo an obligatory sustainability impact assessment, and that is also going longer and longer and covering more content over time. Also, these trade and sustainable development chapters, they set up an own system of dispute resolution, which is a 2-step procedure, starting with consultations, and then second step is a review procedure by a panel of experts. But they are excluded from the classic dispute settlement that is out there for the rest, pretty much, of the free trade agreements. The focus today will be on these 2 issues. I will look into this inclusion of TSD chapters and the language of those TSD chapters, and I will look into the sustainability impact assessments, and then ask the question whether these kinds of changes amount to something that we could call fundamental change in international economic law, that is a sign of a new form of international lawmaking responsive to the Anthropocene. When we look into the language of the TSD chapters, we find this general, this is an excerpt of the EU-Mercosur Free Trade Agreement, we find this general language in Article 1, so saying that the objective of this chapter is to enhance the integration of sustainable development in the parties' trade and investment relationship. notably by establishing principles and actions concerning labor and environmental aspects of sustainable development, specific relevance in the trade and investment context. So the parties do recognize that all these different dimensions are interdependent and mutually reinforcing. So it's pretty much general language, including the principle of sustainable development, into free trade agreements logic, which usually its main focus is the economic sphere only. And with evolving time, as I said before, the content is also evolving. So the newer free trade agreements include a separate article on trade and climate change. And that has varying language, but it's somewhat close to what I put in here from the EU-Mercosur agreement, where in Article 6, Section 2, each party shall, and then A, effectively implement the UNFCCC and the Paris Agreement established thereunder, and B, consistent with Article 2 of the Paris Agreement, promote the positive contribution of trade to a pathway towards low greenhouse gas emissions and climate resilient development, and to increasing the ability to adapt to the adverse impacts of climate change in a manner that does not threaten food production. So we use the term shall, which is rather strong language in international law. I mean, as good as it gets in terms of obligatory. And then effectively implement is also rather strong language. Whereas under 2b, we see a shall in the beginning, but then the next verb is promote. So if we have that kind of a combination of wording, then it starts strong, but then the verb is weak. So it doesn't help much for any future litigation or anything like you would like to argue with this kind of a wording. So we see a bit of a mixture of integration of environmental concerns, like with shall effectively implement, that's going rather far for international law, and the other one is rather weak. We see coverage of different topics over time. So since forests is important, especially in the EU-Mercosur context, they also included an article on trade and sustainable management of forests. But if you check the language here, you again see weak language like shall in the beginning, but then encourage, and again shall and promote. What is then stronger again is this shall and implement measures to combat illegal logging and related trade. So this illegal logging response is framed rather strong, but the rest again rather weak. And what's important to understand is that these TSD chapters, so the chapters that focus on trade and sustainable development, are just one chapter of many that such a free trade agreement has. And I here as an example, I put the example of the EU-Indonesia FTA chapters, which is still under negotiation. And you see here, you have the sustainable development fact sheet component, but then you have other, and this is because it's under negotiation, it's all preliminary versions that are just framed as fact sheets, but they will turn into full chapters of the free trade agreement. So you see that there's a lot of other chapters, like classic regulation that is always part of these free trade agreements. And also, one of these chapters is focusing on energy and raw materials. So the TSD chapter is only one out of many, is important to understand. And also the other chapters play a crucial role for environmental issues, such as, for example, this chapter on energy and raw materials. And now I did a comparison between different EU free trade agreements and the wording in different clauses. And maybe I'll move on to the next slide. So you see the legend. You see here in green, we have all the FTAs that are currently in force. The lighter green covers the EU-Mercosur agreement here, which is still in this process of adoption. And then the yellow one, Indonesia, is still under negotiation. So there's more, but this is the sample that I picked. And then I tried to evaluate the typology of clauses. So if it gets 3 stars, it's rather binding, has language like shall implement. If it has 2 stars, it's supportive language like shall promote, shall support. If it's 1 star, it's cooperative, voluntary language, cooperate, discuss. Some issues are not covered at all. And in some cases, the treaty doesn't even encompass the whole chapter. So if you do this comparison for the free trade, for the trade and sustainable development chapters of these free trade agreements, you see varying degrees of strong language in it. And as you see, not many of them have these 3 stars, but the vast majority has rather 1 or 2. So we see an evolving content in terms of more and more clauses are covered under the trade and sustainable development chapters, but we also see varying degrees of strength in how they are formulated. And then when you look into another chapter, as here, I looked into the energy and raw materials chapters as far as the free trade agreements covered them. You see throughout rather weak language. And if you look into the details, you see even up to contradictory language in these different parts, because what has been negotiated under the Trade and Sustainable Development chapter was not necessarily mainstreamed into the other chapters. And so the point I would like to make here is that the wording in the TSD chapters is still mostly weak. We see some stronger points that were also strengthened over time, but it's still mostly weak. We have usually no clauses on impact tracking. So it's just a status quo negotiation, and then the actual consequences of the free trade agreement are not checked. There's only such a clause in the FTA with Singapore. Then we see that environmental issues are not integrated in other chapters, especially also not in the chapters on energy and raw materials. So what Moises touched upon from a justice angle is also not taken up there. And it leads up to even contradictory regulation. So if we look at the TSD chapters in isolation, we can frame the story a bit more positive, but if we look at the overall chapter and the change, there is not much happening actually. So I would argue that there are slow incremental improvements in the EU FTAs, but nothing that would amount to a fundamental change that is really responsive to the crisis that we have in the Anthropocene. And nothing really towards what Chamo has been presenting in the beginning, that we see a change in the concept of personhood, like no rights of nature recognitions, anything in that way. It's really classic international law in that sense. There is a bit of opening for civil society participation in these review procedures, these kinds of things, yes, but they do not go to the roots of the concept of personhood and so on. So nothing of that we observe in the trade regime so far. Now, since we are at an interdisciplinary conference, I'd also like to take a look into the sustainability impact assessments, which are quite important, in my view, to really analyze the effects, at least ex ante, of these agreements. And then ideally, they also influence the negotiations. And in the case of the EU-Mercosur agreement, the LSE was in charge of doing the SIA. And they did a really large one. It's quite comprehensive and impressive in a way. But I will just give you an example for how they evaluated the effects that the free trade agreement has on CO2 emissions. And through an economic equilibrium-based modeling, the result of this is that through the free trade agreements, we have basically a bit more emissions in Argentina, but small numbers, and a bit lesser CO2 emissions in Uruguay. And basically this evens out. And the overall conclusion here is that this suggests that overall the association agreement is expected to have a negligible impact on CO2 emissions. If you work with these equilibrium models, this is what you actually do find out, I guess. I mean, I'm a lawyer, so my understanding of this whole economic theory behind it is limited, but I guess they have applied those models well. And the question is how can that be if we at the same time know that the trade between the EU and Mercosur countries is full of CO2 intense products. It's basically lots of parts for the car industry and like fossil fuel driven car industry and chemical products going from the EU to the Mercosur, and lots of more agrarian products, soy and beef and coming from the Mercosur to the European Union. So it's a highly carbon intense market. And the way these assessments are done is critiqued, because the result of this is basically saying the free trade agreement doesn't make the current situation any better or worse. It's just perpetuating the status quo. And my argument is that in times of the Anthropocene, this cannot really be the question. So the question shouldn't be, does it just stay as catastrophic as it currently is? But does that free trade agreement actually cater towards and support the process of decarbonization in the EU and in the Mercosur? As such, does it help reaching the NDCs of all the countries involved? And so asking these questions of the equilibrium model is basically asking the wrong questions. So I would argue for that we need to change the trajectory for these sustainability impact assessments and have that more on board. So I think it's good to have the SIAs at all. We also observe an increasing scope and depth, but I would question the adequacy of this equilibrium-based modeling. And there is no assessment really whether those FTAs are consistent or help achieving the objectives of multilateral environmental agreements. And that could happen at the level of the Paris Agreement, but it could also be responsive to the new targets of the Kunming-Montreal Global Biodiversity Framework and so on, and check these effects. So also here with this, in this regard, I would say there are slow incremental improvements, but nothing that amounts to any fundamental change. So with this, I would like to conclude, summing this up. If I search for evidence for this fundamental change, I see some pros. So we include TSD chapters. There is a certain level of integration of trade and environment. We have these SIAs. We do include civil society in the dispute resolution procedure, and we have a two-level cooperative dispute resolution process in place. But the enhanced trade does perpetuate unsustainable production and consumption patterns, deforestation, meat surplus, pesticides, fossil fuels, and so on. The rationales of the TSD chapters are not mainstreamed in these other, 20 plus chapters that these free trade agreements have. The SIA trajectories are not in line with the targets of multilateral environmental agreements. And the dispute resolution mechanism, compliance control that is in place is rather weak and arguably ineffective. It's an enforcement without teeth. So I would argue FTAs are not fit for the Anthropocene, but there is still a long way to go if we really want to recognize this new era of international law and make that also visible in international economic law. So thanks a lot, and I'm looking forward to the discussion.
Thank you very much, Catherine, for that finishing off. So as you can see, there is a sliding scale of optimism and pessimism in the presentations, with sort of global policy kind of out there really trying to make that change. And then we could see how public international law, I was clutching at straws there, but nevertheless identifying some, maybe bright sparks, but being quite activist in how I concluded it, and Catherine being very clear, talking about only incremental, not necessarily a revolution, as we would perhaps want. I wanted to draw attention to the fact that research from multiple disciplines is calling for a transformation in the legal landscape so that we can address the issues that environment is suffering, I suppose. So that was the reason why we wanted to look at international law from this perspective. So in that same way, we're going to briefly have a discussion on two key questions, very, very briefly. And I'm going to briefly share that with you. And those questions are the following. And I'm going to take it in turns, or we're going to take it in turns to answer the question. Do we see a transformation in international law in the Anthropocene? If I could first perhaps give the floor to Moises to answer just a minute or so your response to that, please.
Thank you very much, Chamo. I'll try to keep it within 1 minute. Do I see a transformation in the international law in the Anthropocene? Yes, but my answer goes in this way. Discursively and normatively speaking, yes, we have seen a transition. We have witnessed the recognition of environmental rights, the integration and accountability for environmental harms, emerging concepts, for instance, the rights of nature, intergenerational justice, the different typologies of just transitions. We have seen a shift in multilateralism and the implementation of that. Yeah, and we have also seen more and more how international institutions such as the International Court of Justice and the World Trade Organization and the UNFCCC collecting and guiding their decisions based on scientific research and scientific reports, mostly framed and delivered by the IPCC. So this is the discursive and normative contribution. So yes, there is a transformation. However, in practice, we still see a gap. And what that gap means is a recognition for what is already done. It's not bad. It's not nothing to trash away. No, it's just an indicator that we still need to refine the implementation of these normative and discursive elements of international law, and we need to refine it so in practice we can see them reflected, as I presented in my slides.
Thank you. Catherine, please.
Thanks. So first of all, concept-wise, it really also depends on how you define transformation and what your concept, underlying theory for transition or transformation is. And I like the way Robin Ackersley has been conceptualizing this by saying, which I think caters well to the legal world, because usually scientists more from the social sciences and or STS studies, they do conceptualize transformation as something that comes with a disruption, and disruption is like a constitutive element of a transformation. And this is a bit difficult for legal systems because they will always work against such a disruption. And in the concept of Robin Ackersley of a transformation, she also recognizes in her theory of a green state incremental change, but she only recognizes incremental change if it fulfills the criterion of what she calls critical problem solving. So you can solve problems step by step in an incremental way, but only if you have a critical enough vision that basically works towards a deep and meaningful transformation as the final goal. And only the steps towards this deeper vision of change fulfill her requirements for this critical problem solving. So so I think we see some first incremental steps, but I would still argue that this does not amount to what would be critical problem solving under this definition of a transformation, because the vision is not radical enough. The vision is more like, we fix a bit of a problem here and there, but we keep it mainly at a level of business as usual. And this is also classic for international law. It evolves slowly. It's based on consensus decision-making, not majority decision-making. So yeah, by definition and by the way it is made, it is slow, and of course also hard to be open for more radical visions. And yeah, I agree with Moises that we have them to a certain degree if we take them seriously. Like in the discourse, we have the sustainability as a shared vision in policy enshrined. We have more and more recognition of the justice, the need for a just transition. But what I see in hard law, in actually what kind of text made it into these international agreements, I would say that does not amount to a critical problem solving in the way of that form of a definition of transformation. So I'd be a bit more pessimistic here.
Thanks, Catherine. It's a balance. We do need that. What I'm going to say, and I'm going to be on the highest scale, draw attention to the group of Earth Systems lawyers that are working as part of the Earth Systems governance. My apologies. I think I disappeared there for a second. I'd like to point to the Earth Systems lawyers as the group that are doing that transformation. So yes, not a conventional approach to talking about a transformation in international law, but nevertheless, I think in the current age of change, I see that everyone else, apart from international lawyers, are seeing the potential of the transformation in international law, and maybe that will catch up. So that is the first question dealt with. And then the second question, and I'm not going to risk sharing the slide again, given that we are, I'm losing contact if I share the slide, is each of us are going to give our personal view of what international law in the Anthropocene should look like, our personal vision. Like Catherine said, the vision is missing. So what is our vision? I'm going to kick off this time and state that my vision for public international law in the Anthropocene is seeing a inclusion of further sources of international law beyond what we have now in Article 38. I'm going for the jugular here, but I think that's the kind of transformative change we need. And my suggestion for inclusion of sources would be to, there's one candidate, which is alternate knowledge systems. And from alternate knowledge systems, like indigenous knowledge, traditional knowledge, knowledge of local people, we can draw alternate legal systems. So customary laws, local laws, so legal pluralism, that needs to be represented in the sources. So I would say, let's say Article 38, 1A, or some subsection of that would be customary laws of peoples. Currently, we have customary laws, but that is customary laws of nations, but we need customary laws of people. So with that, that's my vision for international law in the Anthropocene. I am going to pass it on to Catherine.
Thanks, Chamo. So I don't have such a very specific vision yet, but I would argue that you need to work on two ends. So the one question is a procedural question. How do we make international law? Who's on the table? When we make international law, for now, it's only states, and only states have the vote on it. And there's different alternatives being discussed, where how you can include other voices and other forms of lawmaking. Of course, we are far from a world parliament or anything of that sort. So I guess next steps would need to be somewhere in between, but we need a higher representativeness of peoples. I would also support and other societal actors, but it's a very complex question, and there's a lot of arguments in different directions, like who should sit on the table with what kind of a voice and representative for whom and so on. But we need a higher recognition of environmental concerns, the earth as such, and elements of nature to be open in that regard, still open for different forms of framing. And so this is for the procedural side important. And on the substantive side, so the content that we actually write into these laws, I think one huge problem is still that we have this highly fragmented international law. So these regimes like human rights law, international trade law, international environmental law, they have been developed in isolation from one another, and they don't communicate much with one another. And I think the specialization as such is fine. It has happened like that, and specific material also needs a specific legal regime, but it needs to be thought much more integrated, and we need to take the principle of sustainable development or whatever future version we want to formulate of that as an overarching goal, like and we have it theoretically in form of SDGs. We have such a thing that could almost substitute a constitution at a nation state level as an overarching vision, but we do not integrate that into the actual legal regimes. They do not communicate with one another, and they do not respect each other's targets in one holistic system. And that is something we need to urgently address on the substantive end. Plus, we need to make those planetary boundaries that we accepted in the targets of different multilateral environmental agreements in the, as the boundaries also for the other regimes. So that needs to clearly also become a boundary in international economic law. We need to try to use international economic law as a motor to reach those targets, because the transformation really needs all hands on deck. And we need to use that regime to also fulfill these targets. And there is a lot of an important role for the market to make us help address these issues also in a just transition way, but it needs to be steered in a proper way. Otherwise, market forces do not automatically, I mean, as we obviously see, to just sustainability transitions if they are not hedged in a certain direction.
Thank you. Moses.
Yeah, I think I align pretty well with Catherine's vision and statement too. I think what we are missing is a holistic perspective of the problem. We're also missing the transformative change implementation of the normative discourses. And more specifically, we're missing a system dynamics perspective on the problem. In my experience, I've been involved in the carbon management strategy policymaking process in the EU. And I've been, like, to a lesser extent, involved in the Critical Raw Materials Act. And what is very common is that we still operate in silos. When there is a call for evidence by the EU, we mostly see, let's say, around 3/4, 25% or more of representatives from the private sector to come to give their opinion, their needs, their interest. And there's nothing wrong with that. The problem is the number, the problem is the size, and the problem is that we need to make an extra effort to reach out to a more systemic and wider spectrum of voices to be considered in policy making process. And this is if we really want to make transformative changes. Otherwise, we are just reinforcing the business as usual scenario by only taking into account the same exact voices in transforming our environment, its concerns, and the peoples that live in this earth.
Excellent. Thank you very much. We've got about 10 minutes for the discussions on floor. So participants, attendees, I don't know, Blake, if you could just, get them on camera too, if it's possible, to make them panelists as well at this point. Yeah, or feel free to write your comments on the chat box if you've got any questions at all. Clarifications. Yeah, Blake says raise your hand to ask a question directly. to the panel. Excellent. The countdown starts now. Otherwise, we can all go off for breakfasts or lunches and dinners early. I'm just giving a little bit more time for the attendees. I can see one of our ESL Earth Systems Law Task Force convener is there, Rak. I wonder if you have any comments about Earth Systems Law and whether that might bring a transformation. Hi, Rak. Sorry, Kim. I saw that there. And I think Kim is just joining, or Moses in the meanwhile. Your quick question, if I'm before Kim. Yeah, you raise your hands, didn't you? Oh, you didn't? Okay, I thought you raised your hand. Okay. Kim, did you want to say something? Or, sorry, I put you on the spot there. Yeah, Kim's raising his hand. Blake?
Yeah. Hey, I'm joining
Hi.
from home, so fully ready for the video. I did put a question in the Q&A, which is a question for all of you. So which is about, yeah, I mean, as a task force, as members of the task force, what sort of research questions should we explore next? Do you have some suggestions for, in terms of research agenda?
Catherine, do you want to go first, perhaps?
Yeah, I mean, exactly that. We could ask the question of the whole, the title of that panel. Basically, if we need a new era of recognizing the Anthropocene in international law, and then evaluate how far we are in that era or not. So search for evidence for different signs of responsiveness to that, the challenges of the Anthropocene and changes in international law, but also find evidence for where that is not the case, and then develop suggestions for how we could move on further, taking on board already the principles and theories that have been developed under the Earth System law so far. So you've published on these issues. There's a lot one could take on board from that, but looking then more specific into different international legal regimes, and yeah, try to link that. So that I think could be interesting and worth a try.
Maybe I'll answer that now. I'm going to be provocative because I think it's important to really ask some, tough questions. My, research question I'll pose is really, should Indigenous law, or is Indigenous law already Earth Systems law? And that's the question we need to look at. It's linked to my suggestion of transformation of international law as well. But I think it's important we don't reinvent. We don't reinvent what we've already done, and to give that recognition. It's not, I think, just important to listen to the voices of diverse people, but it's important to take into account diverse ontological approaches to earth and to law, which already is existing in alternate legal systems, and legal pluralism would be that theory that will allow us to do that. So I think the questions should really be about, in times of climate emergency, can we take that template and apply it and give it that much of, authority behind it? And that'll be my research question. Is Earth Systems Law really indigenous law? Most.
Well, I don't have particularly any suggestion for the research question, so I'm really not going to waste your time, but I have to admit that these past two ideas from my two colleagues are good insight for questions. Perhaps we can already place some time frames to the Anthropocene era, and we can already have as that time frame the climate target by 2050, by 2030, and the intermediate goals by 2040. Perhaps we can try to push for 2030, 2040, and 2050 to be the end of the era of the Anthropocene. Of course, by first giving recognition to we are already there, and the goal is that that era finishes by 2050. If we do want so to happen, then we really need to give 100% recognition to a new level of international law. That will be, it's not a research question, but that will be one of the ideas behind the research questions proposed now.
And if I may ask a question to you, Kim, what is your vision? Like, where do you see room for these kinds of questions under the task force, or does that fit to some ideas that you already had? Like, I didn't have time to attend the other session, so maybe you have discussed things like that there. I'm not sure.
I mean, I think the central question that this panel has addressed was really, really useful and convincing to me. So whether you see evidence of transformation in existing international environmental law, and that, yeah, so I think we need to kind of take stock of what has been changing and in which direction are we making changes in international law and other forms of law. And try to also steer the direction of evolution and pace of evolution towards what we call Earth System Law. So yeah, these are really interesting questions, and I really enjoyed the presentations. Thank you very much. Yeah, thanks.
Thank you very much for all of that, and apologies I didn't see your Q&A. It's a bit early in the morning for the session for us, but that's great. I think if there are nothing else, then I think we'll be finishing 1 minute ahead of time. So yeah, look forward to the recordings coming up and further conversations. Thank you all.
Thank you.
Thank you very
Bye.
much.
Thanks a lot.
Bye.
See you.